now.
Good morning, Senate Judiciary, January 21st, 2021. This morning, our agenda is to discuss the Justice Reinvestment Working Group's recommendations regarding probation. And we have with us Sarah Friedman from the Justice Center, who will present that portion of it. And then we will talk about a bill that is still in draft form that will be introduced dealing with probation. So if we could start with Sarah, welcome to Senate Judiciary. And Sarah is with the Council of State Governments Justice Center out of, well, the Justice Center is in New York City and Seattle and Austin and Washington, D.C. and somewhere else.
Basically all over the place, because now we're all remote.
Because everybody's remote. You're all over the place. Welcome, Sarah.
Thank you. Thank you so much, Senator Sears, committee members. Just to repeat, I'm Sarah Friedman. I'm a Deputy Program Director at the Council of State Governments Justice Center. And I'm really thrilled to be here to walk you all through the work of the Justice Reinvestment 2 Working Group, and specifically on their probation policy options. So the Justice Reinvestment 2 Working Group actually had a report due to you all on January 15th. And that's what I'm going to kind of start with. The report covers a few things, including probation, but I figure for this, we're focusing on probation. I can give you kind of a brief refresher background on who the Justice Reinvestment 2 Working Group is, and then dive into the conversations that they had over fall 2020 on probation earned credit, strengthening the midpoint review process, and just ways to safely help people earn discharge from probation.
Would it be easier to have the screen, have Peggy or Bryn or somebody put on the screen the working group report?
Yeah, I can actually share my screen. I have it up.
Okay.
So let me hopefully make that happen. Here we go. Can you all see this?
Yep.
Hold on. And now hopefully you see it large. Yeah, in large form. Okay.
Yep, now we do. Yep.
Nice.
Okay. So this is just, so if folks are looking through the entire report, this is just the title page of the report that was due January 15th. There's 5 sections to the report. I'm really going to just briefly go over section 1 just as a background introduction and talk about section 2. I hope that, at other dates, we'll be able to walk you through the other sections of the report. My colleague, David DeMora, who you all may remember, he's been kicking around Vermont for a really long time now, helping with projects here. He's really the expert on the mental health and substance use pieces of this report. And at some point, I would love for him all to talk to you about that part. But I'm focusing on 1 and 2 here.
Right.
So just as a reminder about Justice Reinvestment 2 in Vermont, the process started in June 2019 when state leaders from all 3 branches of the government wrote a letter. Oh, no, 1 second. I'm sorry, I hope that sounded okay for you guys.
Yeah.
My phone just dropped. Wrote a letter, to the federal government, to the Department of Justice, Bureau of Justice Assistance, who funds this project, really asking for the CSG Justice Center to come in, analyze Vermont's criminal justice system, and help the state propose policy changes that would improve Vermont's criminal justice system. That process began the Justice Reinvestment 2 Working Group, who met throughout fall of 2019 and culminated in policies that were adopted in the 2020 legislative session and turned into Act 148, which was enacted in July 2020. So this is really like the 2-sentence version of a huge amount of work that was done by Vermonters and the CSG Phase 1 CSG Justice Center staff, or what we call our Justice Reinvestment team, led by Ellen Whelan-Wiest, who I'm sure you all probably remember very well. So,
Yes.
so that's everything. That is it in a nutshell. And Act 148 has some wide-reaching policy changes around presumptive parole, streamlining the parole system, a whole bunch of stuff, which is listed here. But for this conversation, the really important thing is that Section 21 of Act 148 continues the Justice Reinvestment II working group. So at the time it was an 18-member body. Now it's a 19-member body, which I'll show you who's on it in just a second. And it really it continued the working group and gave them additional tasks. So it said, hey, Justice Reinvestment II working group, we want you to oversee the implementation of policy changes for justice reinvestment as that progresses. And also there are some additional studies. We'd like you to evaluate additional policies moving forward. So just trying to switch the slide. So this is the Justice Reinvestment II working group, 19-member body. Senator Sears and Senator Nitka are on it, so they know this really well. It continues to be chaired by the Chief Justice, and just has people from all 3 branches, different actors from all across Vermont's criminal justice system, putting their heads together on how to improve criminal justice policy in the state, and also overseeing implementation of policies that have passed. And just to note, the one change in this from the last time the working group met is that a representative of the parole board was added onto the group to make it a 19-member group, and that is Mary Jane Ainsworth, the director of the Vermont Parole Board, is now on the group. So the Justice Reinvestment II Phase 2 timeline. So once Act 148 was enacted, the CSG team, the Phase 1 team who went through the working group process for the first time, passed the baton to my team, who really focuses on implementation of policies once they've been passed. Vermont state leaders, again, from all 3 branches, had to write requesting that CSG stick around and help with implementation, and BJA approved that in August. And then the working group hit the ground running again and met 4 times between September and January 2021 to tackle their statutory duties facilitated by the CSG Justice Center team. And while this is happening, we're focusing right now on the working group and these probation policy options. But just to be clear, while the working group process is happening, your state agencies are also, doing a ton of different implementation work that the CSG team is helping out with, setting up data monitoring, getting policies and procedures in place, and a whole bunch of stuff preparing for January 1 effective dates of Act 148 policies. So the Act 148 gave the Justice Reinvestment II working group a long list of areas to study and make recommendations. And since we were on a pretty short timeline, since there was also this January 15th report due, at the first meeting, the working group discussed how they were going to what they were going to tackle then, or what they were going to prioritize specifically for the report due on January 15th. And the first thing that was decided to prioritize, which also needed to be prioritized in statute, quite frankly, was studying earned time for people on probation and other related policy options. That was required to be reported on in the January 15th, 2021 report, as opposed to other things that had flexibility to go into the January 15th, 2022 report. In addition to the probation conversation, the working group did also decide to tackle 3 interrelated tasks related to mental health and substance use needs for people in the criminal justice system, and really specifically about information sharing, case coordination, collaboration, and collaboration on services for all of the different agencies and people working with folks with behavioral health needs in the criminal justice system. So I am skimming over these now, but we are definitely happy to dig in much further into them at a later date. So this is just the really quick schedule of the 4 different meetings that took place of the Justice Reinvestment Working Group. And just for this conversation in October, the group really looked at data related to Vermont's probation system, and I'm going to give a really high-level preview of what that data was. And then that conversation on probation was continued in November. We honestly kind of ran out of time in the October meeting, and so working group members continued to discuss these probation policy, probation earned credit or other related policies in the November meeting. The November meeting also dug into behavioral health, the substance use and mental health, and we discussed justice reinvestment funding and appropriation recommendations for the upcoming budget cycle should funding be available. So that leads us up just to last Monday, January 11th, where the working group came together and was presented with policy options that were adopted around all of the different policy areas that the group was studying. So when I think through the work that the working group did on the probation earned credit, one thing that I do want to be clear about is that this has been a really long-standing conversation in Vermont that existed long before the CSG team was running around helping you all analyze your system. And our understanding is that this has just been a conversation for a number of years where folks were just having trouble coming to consensus on, what the best mechanism might be in order to help people earn time off of their probation sentences. So it comes out of the working group tackling it comes out of these statutory duties, but I do want to note it's a little bit different for the CSG team because we didn't tackle this policy because our phase 1 data analysis led us there. We tackled it because Vermonters were saying, hey, we've been talking about this for years and we need extra facilitation on figuring out how to get there. So that, I just want to note that you're going to see a little bit of a different approach if you've heard Ellen present on these things or, you've seen what CSG has done in the past. We took a little bit of a different approach to this because we were coming in midway through a very long conversation Vermont was having on this, and really facilitating it, but also trying to lead you guys in a direction that you were going without, I guess, unduly influencing where you wanted to go. Because honestly, the data wasn't quite there for us to do our normal thing, which was to, find the really obvious policy that we could say, hey, you should definitely do this. And I'm going to walk you through that.
I think it's important if I give a little bit of a history, Sarah. When we did Justice Reinvestment 1, we did make some changes to probation because what the Justice Center did find at that time was that we had around 12,000 people on probation. Many of them were dead. Others who've been on for 30 years because they hadn't paid a fine or hadn't paid a surcharge or whatever. So we made significant changes and we reduced the probation population to around 8,000. And it continues to be less today with diversion and other alternative justice. But it's important to note where we were back in 2010 when we did the first Justice Reinvestment. Just as
Thank you, Senator Sears. That's really helpful. So just digging in, Act 148 actually had a good amount of language on this, and I think these kind of questions that were in Act 148 were the result of these years of conversations about this, and particularly the result of, I think, a pretty robust conversation that was had during the 2020 legislative session. So the working group was specifically tasked with evaluating a policy for people earning 1 day of credit towards their suspended sentence for each day served in the community without a violation. So that was there was already some details hammered out, you can say, on the basics of what an earned credit policy would look like. But the working group was also asked to think through a variety of questions, like how would Vermont implement this policy without impacting probation, the length of probation terms or suspended sentences? You know, if there's a credit enacted, should that credit apply to the maximum or the minimum suspended sentence? You know, and kind of walks through some pretty specific questions. And along with that says, you know, please study additional options for early discharge from probation, including options modeled after Vermont's current midpoint review process. And I point out that one specifically because the working group discussion really ended up going there, which you'll see reflected. So when the CSG Justice Center team kind of hopped in to start facilitating this conversation, one thing that we really wanted to talk about to the working group was, hey, what are your goals for this policy? You know, different people enact similar, or different states enact these policies for a variety of reasons. And if we're leading the conversation, it would be really helpful to understand what Vermonters are hoping to get out of a policy or something similar. So one, you know, and some of these are pretty easy. So we know that these policies provide people on probation an increased incentive for positive behavior change. So it's kind of like the kind of evidence-based practices tell us that incentives or, you know, rewards for good behavior actually are really, really important for creating behavior change for people in the criminal justice system. And this is, you can think of it as the ultimate reward. Like if I'm doing really well, if I have good behavior, if I do everything I need to do and prove that I'm a good citizen while I'm in the community, you know, I can earn I can earn time off my sentence. It's a really powerful motivator for people to increase kind of individual public safety. Another really common goal for policies like these is also focused on public safety, increasing probation resources for people who are most likely to reoffend. So if all the people who are really motivated and are doing really well on supervision are able to earn time off their sentence and transition off, then your probation officers are able to focus their time and resources and attention on all the folks who are not doing well on probation, the folks that need a lot of support, who are messing up, who kind of need that intensive supervision. Well, now they have more time and attention for people like that. So it's really it also is really about resource allocation often in states enacting these policies. Now, where I think folks on the working group were kind of not all necessarily on consensus was about where in Vermont this policy for decreasing the length of incarceration for a person who gets revoked from probation. So if they're successful for a time in the community and then are mess up and are revoked back to prison, should this policy decrease that length of incarceration, or is the goal of this policy to decrease the overall probation term? And I think a lot of people on the working group will say both, definitely. But I think that through the conversation, there were some folks on different pages on, is the ultimate goal about the amount of time someone can spend in prison once they mess up on probation, or is the ultimate goal about reducing the probation term successfully? And so there was conversation about that during the working group meeting. So what we could do, what CSG Justice Center staff could do was really, we wanted to see, well, what does the data tell us? What can we tell you about your probation system? So if you all are thinking about shortening probation lengths and about what happens once someone is revoked from probation, then what we want to know is, well, how long are probation lengths currently? And when do people tend to be revoked for probation? How long are people successful on probation? Or, you know, how long until they mess up? And so we did a data analysis focused on kind of what the current probation system looks like. I have a selection of slides here. This is actually a good deal shorter than what we initially presented in the October meeting. I'm going to try to go through them quickly to not get like too stuck in the data. But if you're more interested in, if you're like a really quantitative person and you want more charts about the probation system, there's more, there's kind of a more in-depth version of this presentation took place in October. So if you look at misdemeanor probation lengths, almost all probation lengths, people who get misdemeanor probation have terms of 2 years or less. And it's really consistent in Vermont. And this is likely due to the fact that you do have a state law on the books that states that misdemeanor sentences are not to exceed 2 years unless the court deems a longer period appropriate. And it seems very uncommon for the court to deem a longer period appropriate. So you see in this chart, you know, the majority of folks get 12-month terms. And the majority of folks get 12-month terms on probation, and then you do also have kind of a spike at 24 months. So a lot of people do get 24-month terms of probation terms. But the thing about Vermont probation sentences is they actually have 3 components. You have the length of time someone is sentenced to be on probation supervision, and then you also have an underlying suspended sentence that has a minimum term and a maximum term. And the point of that suspended sentence is that if someone is revoked, if they mess up on their supervision, then that is the period of incarceration that they can serve once they mess up on their probation. And so when we look at misdemeanor probation terms, the minimum and maximum tends to be actually a lot shorter than the actual probation term. So, across all different probation term lengths, people tend to have a 3 to 9 month sentence for that underlying incarceration. And if you look at these longer people who do get the longer misdemeanor probation terms, you know, there tends to not be a max sentence over 1 year. So no matter how long your probation term, when you mess up, you're very unlikely to go into incarceration for over a year in Vermont. And just to note also, you know, we're looking at these minimum and maximum sentences because that was part of the statutory duties, you know, should a credit apply to the minimum, should a credit apply to the maximum. So for felony probation terms, it looks a little bit different. The guidance on the books for felony probation terms is that they should generally not exceed 4 years unless the court deems the period appropriate. But in a good number of cases, the court has deemed the period appropriate, and you do have a decent number of folks who have been sentenced to 5 years on probation. So you see here, if you're looking at this chart, kind of all the spikes of the blue bars are on the year mark. So a lot of people at 2 years, a lot of people at 3 years, and then the next 2 spikes are 4 and 5 years. But still, in general, very unusual for anyone to get over 5 years for a probation term. Generally, you know, people are on felony probation or sentenced to felony probation to 5 years or less. The minimum and maximum sentences do look a bit different. So for folks who are sentenced to more than 2 years of felony probation, their maximum sentence generally is the same as their probation length. So you're sentenced to 3 years of probation, and if you mess up, they can put you in incarceration for a maximum of 3 years. However, for 2 years and less, the maximum is actually longer. So for a typical person, they're sentenced to 2 years of probation, but they could, if they mess up, they could actually be incarcerated for a maximum of 3 years. So that's kind of a pretty interesting kind of what have you on how probation sentencing structures work. But generally, for felony probation sentences, across all different felony probation sentences lengths, that underlying sentence is typically 1 to 3 years. So now just looking at when are people revoked from probation? So that is really thinking through what is that public safety risk. So for misdemeanor probation, on average, across all different probation sentence lengths, a person who messes up and gets revoked will do so in their 7th month of supervision. So really early on within that first year. Most revocations for misdemeanor probation occur well within the first half of someone's sentence. So you see here on this chart, it's just based on how long the probation length is, when is a person typically revoked, or the average time to revocation. And, you know, so on misdemeanor probation, so, you know, for folks who tend to have 1 year probation terms, they're usually revoked if they mess up in their 5th month. That's what this chart shows.
Can I ask a question about that, Sarah?
Yeah, definitely. Please.
So the numbers on the bottom are the amount of time they were put on probation for, like the 2 years. They're on probation for 2 years, and they typically screw up during the first 8 months. Is that the way I read this?
Yep.
Okay.
Yep,
Thanks.
exactly. Yep. And so now we have the same chart for people who are on felony probation, have been sentenced to felony probation. So, and this is actually in some ways pretty similar. It's well within the first half of the sentence are people who, if you're revoked, you're typically revoked well within the first half of your sentence. You have on average across all the different felony probation lengths, a person would be revoked in their 11th month of supervision. So again, even before their first year is up. But it looks a little bit different, based on the length of sentence. So for example, this chart shows, if you're sentenced to 2 years of felony probation, that person is typically revoked. If they get revoked, they're typically revoked, within their 8th month on probation. Sorry, was there another question?
No, thanks. Sorry.
Okay. So this is to say we were able to, I think, dig in and kind of give folks on the working group a pretty good picture of kind of what probation sentencing structures look like. But we also knew that Vermont currently had a few different mechanisms on the book to shorten people's probation sentences. And we weren't able to access any data, or we couldn't figure out how those mechanisms were currently being used and what that looked like. So just so you know, there's DOC is able to file a petition anytime someone completes their conditions of supervision, whenever that is. DOC can petition for them to be discharged. And then there's also the midpoint review process that at halfway through someone's probation term, DOC may file a motion to discharge people who are doing well. So we knew these existed, but we don't have any picture of how well they're used. There's a lot of anecdotes that they're used a lot or they're used a little. It depends who you talk to. And even if the petitions are filed, no idea if judges were approving them, how long people were earning off their sentence, et cetera. So we kind of felt like what was currently happening around this in the state is a black box. Which is not what, quantitative people want to hear, unfortunately. So what we have here on this slide is just a list of things that we really wanted, the questions we wanted answers to really help you all have a full picture of what was going on to Vermont, but we weren't able to answer. So, not only what's going on with those current mechanisms, but also how do those minimum and maximum suspended sentences correlate with the actual amount of time someone spends in prison? We only know how long they could spend in prison. We don't know how long they actually do spend in prison, because we do know people often go from probation out onto furlough. They're just moved into a different type of community supervision. And on the same line, for people who do mess up on probation, go back into DOC custody, and then come out pretty quickly on furlough, what are those, what are their outcomes for those people on furlough? They've just moved to a different type of community supervision. What does that look like? And then a whole host of questions, as I said, on, what's currently happening in the state. So even though we couldn't answer all the questions we wanted to Vermont specifically, what we can say is there's a lot of national data to support these policies. So 38 states across the country have some form of either earned compliance credit or earned discharge for people on community supervision. But of course, those policies can be structured wildly differently depending on what state you're in. And during that October meeting, we did walk the working group through 3 or 4 state examples, one being Montana, which came up a lot, but I think it was Montana, Missouri, Michigan, and one other. I think we were on an M state roll apparently, where we kind of walked through what different policies states have enacted around this and how they can be structured differently. So again, this isn't in this report now for the sake of kind of brevity, but those are available. And then really interestingly, between the 3rd and 4th working group meeting, Pew released a really comprehensive study of these policies specifically. It was one of those things where it came out in December and the working group had just finished talking about this on November 24th. And it was like, oh, the timing. This would have really informed the conversation. So Pew, there's now a really comprehensive study from Pew that walks through the national data on these policies that help people earn time off their probation terms. And that comprehensive study does find that many people who are on supervision serve longer terms than are necessary for public safety. And that states that haven't.
Sarah, would it be possible for you to get a copy of the Pew study to Peggy so she could post it on our committee webpage?
Yes, definitely. Will do.
And also, Peggy, if you were able to provide any committee members with hard copies of both the Pew study and the entire Justice Reinvestment 2 working group document, it would be appreciated. I think most committee members would want to have the hard copy if they could be sent to us. Thank you.
No problem. So yeah, I will send that on. It's a longer read, but it's definitely worth it. It does walk through a few different states that were able to study their earned discharge or earned credit policies and found that it did not, negatively impact public safety, which is really important. That states are able to safely reduce terms without that impact on public safety. So the real kind of the conclusion of the report is that the study recommends to state policymakers that they do adopt similar policies to what Vermont is considering. And this is the three kind of types of policies that Pew lays out. One is this goal-based supervision to prioritize outcomes as opposed to time-based supervision. So as we talked about on the goal slide, to allow people to earn time off their sentence for good behavior, earned compliance credits that promote positive behavior change, encourage compliance, increase successful outcomes, and reduce caseloads. And then also they recommend an automatic review of supervision to ensure that states use clear and definable guidelines to determine eligibility for earned discharge to ensure fairness. So all things that the working group discussed and kind of was going towards themselves. So coming out of this, what the CSG Justice Center team did is after the October and November conversations on earned discharge policies and midpoint reviews and earned credits, we worked, since this was, as we said, we didn't have all of the data we wanted about this policy, and we were kind of jumping in midway into an ongoing Vermont conversation. We worked to develop or to present to the working group two different policy options that we felt like reflected back to the working group the conversations they had in those two meetings. So usually when CSG presents policy options, just to put our cards on the table, we call them policy options, but we really want Vermont to adopt all of them. They're really, they're things that we think that you all should do. It was a little different this time. This time we kind of presented two policy options, and we said, we really think these are either or. You either do an earned credit policy or you do an earned discharge policy, so time-based versus credit accrual. And the way we've developed these is reflecting back to you where we think folks in the state are on these, since we don't have all of the data to model policy changes the way we normally would. So option one was sticking with the credit accrual policy. The basis of the statutory language in Act 148 to study was that day-for-day credit for folks on probation. There were some working group members who felt strongly about this, and the recommendation was, if you all want to do a day-for-day credit as an ongoing, has been a conversation for a few years in Vermont, definitely apply that to the underlying minimum sentence. And then there's an option to apply it to the underlying minimum sentence until there's only 15 or 30 days remaining to ensure a minimum of term of incarceration is available for revocation if needed, which was really a compromise way to structure the policy. Once the conversation in the working group meeting happened, option one was not adopted, in favor of option 2, which I'm about to present, and that is to say we did say we think you should do one or the other, not both, so it makes sense. Basically, the working group chose the other option. I do want to note, though, that there was comment, and the ACLU did say, hey, we still like the earned credit policy, and we don't think this has to be either or. We think this could be a both and. You could do both of these. And so we did kind of register that comment in the report that, you know, not everyone felt like it was one or the other. So the option that was adopted was to strengthen Vermont's current midpoint review process to make it more presumptive and encourage its use using a model of earned discharge policies from other states such as Montana. And then these bullet points here kind of are a very high level. If you look at Vermont's current midpoint review statute, you know, go from DOC may file a motion at midpoint review for DOC shall file the motion. As in Montana, require judges to grant the request for discharge unless they determine it's not in the best interests of the person on probation or would present a risk of danger to the victim. And then also to make sure that even if a person is not eligible or is not granted discharge at their midpoint, they have other opportunities to earn discharge. So kind of, you know, if they're not doing well at the midpoint, but they get their act together, that they can still kind of work their way to earning some time off the end of their sentence. So that's kind of the very short version of what Bryn has been working on. And this is what the working group did end up adopting. There is a note that the Network Against Domestic and Sexual Violence did speak up during this and say, you know, that they thought it would be really important to make sure that the rights of victims are taken into consideration and that there's a proper notification and communication processes around this as it moves forward. So that's noted in the report. But this is kind of where consensus landed within the working group, is taking a mechanism already on the books in Vermont, which we don't know exactly how it's working, and just like really beefing it up and making it more like traditional earned discharge policies in other states. So that's really the crux of it. The one last thing is just a reminder from us is that no matter how you structure your probation system, if you really want to reduce revocations and reduce people going to prisons, you've still got to focus on strengthening the effectiveness of how people are being supervised in the community and ensuring that people receive the services they need, especially around mental health, substance use, and co-occurring disorders, and increasing those, you know, community-based resources. So just a reminder from us, we can't help ourselves, that you all, you know, there's kind of like a robust and holistic way we have to be, the state should be tackling this if we want people to be successful on probation and limiting their incarcerated sentences. And this is also to say you all are doing this as part of Act 148. Your DOC is working really hard on improving supervision practices and making them more aligned with evidence-based practices and formalizing incentives and all of that. So these are things you're doing, but they all go hand in hand.
I just comment that I think this is the most critical area, and given that 3 members of Senate Judiciary are on the Senate Appropriations Committee, this is where we really need to build a fence around the money that's saved from justice reinvestment too, and that it's spent on community services, particularly for offenders who are on probation. I think sometimes we focus on other offenders who are out in the community, those on furlough, those on parole, perhaps, and those, you know, who are receiving alternative sentences like diversion. I really think we have to focus on these probationers, because that's where I can't think of the percentages we found in the initial report, but it's around 70% of the returns are probation, parole, or furlough.
Yeah, I should, but I don't have the exact percentage off the top of my head, but I think it's around 70%. But really the overwhelming majority of people entering prison are returning from some type of community supervision.
Okay. So if that's, that this is a place, I might add that, that the more we talked about the earned credit versus this particular way to do it, the earned credit was so complex that I thought we would get into real difficulty in trying to implement it. And I personally, and Joe, you're probably familiar with it now, no, Alice is, in a juvenile system, we have a yearly review, I think it's yearly, of any child in custody. So that child, you really have to say, this is why the child should be continued in custody or not. And so this is the type of review that I hope will come about as a result of this legislation passes. That it be a very serious review of whether or not that person should stay on probation. Have they completed it, and shouldn't they be released? Sarah, thanks so much. I don't know if there's questions for Sarah or Bryn, but it was a really good presentation of where we got to. I felt it just doesn't seem to me like there were only 4 meetings. I felt like I was a lot more than 4. But
I'm not sure if that's good or bad, but
well, I'm not either, but it just seems like I don't know if Senator Nick has a comment on that.
I think it was absolutely incredible, the amount of research and data that came from the council because of the work that was done. I mean, it was very, very thorough. I mean, you could really look at it and figure out what is what in the system. I thought, I was really surprised at how much information they were able to get. Because it's not easy to gather all of that. I mean, we have in Judiciary been receiving different things from time to time, but to have this really comprehensive look was really very good. And, data driven, as they say these days all the time. So thank you.
Thank
Can
you.
you
And
expand could you expand a little bit more on the Pew report and the findings that it doesn't affect public safety to provide this?
Yeah, so that's really looking at it's similar to kind of the analysis we started about, when do people, do things adverse to public safety when they're on probation? So when are people tend to be revoked? And what a few states were doing, and I think it's Missouri specifically, is that they tracked people. So after they implemented earned discharge or credit accrual policies, they tracked the folks who earned time off their sentence and looked during when they would have been serving, did those people commit new crimes or do, things adverse to public safety? And they found that generally they did not. So that it wasn't, so even when the folks were not on supervision, they, no one suddenly got off supervision and then went back to their criminal lifestyle, et cetera. They continued to be good citizens as they had shown they did when they earned time off their sentence. So there was no uptick in crime from the folks who had their sentences shortened.
Other questions for Sarah? Can we briefly walk through the bill with both Sarah and Bryn? That might be the most helpful way to see how what CSG found is now making its way into the draft. I believe it's draft 1.3.
That's right. Draft 1.3. And if the committee wants me to put it up on the screen, please let me know.
It'd probably be helpful since I'm probably the only one that went and printed it out this morning.
Okay.
This is blind faith. I'll tell you, we're signing on without ever having seen it. We don't have any idea what you're saying.
Well, actually, it's you can change your mind, but what Sarah just reported is what's in it.
I suspected that.
So.
Yes, and to be clear, this is a bill that has not yet been introduced. It's a draft. So it may yet change prior to its introduction. Okay, here it is. So it is draft, hold on. It is draft 1.3. And right now, all 5 of you are co-sponsoring it. So you'll let me know if that changes after I walk through it. So for the record, Bryn Hare from Legislative Council. Note that this draft, because it's sort of a work in progress, it hasn't been edited yet. So for all of your eagle eyes, that if you see something, know that our editors haven't reviewed it yet. So
And also, Sarah, if you see something, please feel free to jump in.
okay.
Will do. Thanks.
So I'll go ahead and walk through it. I'm going to start by saying that, and I think Sarah really did a great job of talking about how our statutes currently provide for this midpoint review process and probation in general. But I'll just start out with kind of an overview of what's happening now with respect to the midpoint review. Then the changes that this bill makes might make a little bit more sense.
Feel free to run them.
So what this draft changes 2 statutes. It changes the duration of probation statute.
They can't hear it.
And then the conditions of probation statute. So what the conditions of probation statute sets out currently is that the Department of Corrections has to review the record of people who are serving probation sentence during the month prior to the midpoint of the probationer's probation term. So after that review, if the probationer has successfully completed a program assigned as a part of their probation sentence, or has attained a goal or goals that were specified by the conditions of their probation, then the department may file a motion with the sentencing court to request that the sentencing court dismiss the remainder of the probation term, or requesting that the court deduct a portion of the remaining term based on the probationer's success in their programs or attainment of their goals. So that's what's happening currently, just as a reminder before we go into what this bill does. So section 1 is the duration of probation statute, as I mentioned. And currently the only language to the statute is found here in what is now subsection A. And it just says that the court that puts a person on probation, as the sentencing court, can terminate that probation and discharge the person at any time if termination is warranted by the conduct of the offender and the ends of justice. So what we've added here is some language that refers pretty specifically to the following statute, which is in section 2, which we'll talk about next. So what this says is that what the court can do changes here. Upon the recommendation of the department, the court shall terminate the period of probation and discharge that person prior to the expiration of their term, or grant the specified term deduction, grant a motion to reduce the term pursuant to this following statute, unless the court decides that by clear and convincing evidence, discharge is not in the best interest of the person, or that discharging the person will present a risk of danger to the victim or to the community. And it also specifically requires, you see the sentence, this last sentence here, that the court has to set forth the reasons for denying that motion on the record. So that is the directive to the court. The next section is the conditions of probation, and this is where we see the directive to DOC. So changes here, we've just added some subheadings. I'm going to scroll down to the substance of the change here. These are all the conditions that the department can place on a person. So here in subsection D, this is where the bulk of the changes are made. So we've added a subheading here that specifies that this is the subsection that's talking about the department's review and recommendation for discharge from probation. So what this language provides is that the department shall, you see that word shall, file a motion requesting dismissal of the remainder of the probationer's term if the person doesn't have a violation within the last 6 months prior to the department's review of their record and is actively participating in their case plan.
Bryn,
Yes?
just a question there about the word actively.
Mm-hmm.
Is that meant to be a a discretionary point for the commissioner?
I'm not
Because-
sure about its intent. I do think it reads that way.
Because if we have it in there, it sounds like we're deliberately allowing the conditioner more latitude than the shall would seem to indicate. So if you got rid of actively and just had participating, it's less liable to argument, I would think.
I don't disagree with that.
Can I
Okay.
follow up on that? Senator Sears? Can you
Yes.
hear me?
Yeah.
Oh, okay.
Please.
So the other thing I think is that the case plan often involves, anywhere from 2 to 10 or 12 different, I don't know what you'd call them, directives, or, I mean, it isn't just one thing. So if somebody is actively participating in 7 out of 10, does that mean actively, or does that mean they have to be actively participating in 10 out of 10? I think that needs a little clarification there too.
If I can just add a little
Please,
background
yeah.
on this, the terms that we were using within the Justice Reinvestment 2 meeting was kind of shorthand. We were saying is complying with all of their conditions of supervision or has completed all of their conditions of supervision. And that language that this is kind of fleshing out, like what does it mean to be, I think DOC might say completing all of their conditions of supervision. So I think that this is definitely a place where that could be edited or modified, and having input from DOC would probably make a lot of sense as to what, like how do you define kind of with less wiggle room what it means to be compliant with your conditions of supervision. And so this language is kind of a first draft of that, or a first stab at that, because saying you've completed or you've been compliant with all your conditions of supervision also feels like it's not quite, it could be a little bit too wishy-washy, or, it's not quite clear enough. But I think that, also that, having to have violated terms of probation with the court at the 6 months prior to consideration, is 6 months the right amount? I think that also could be a conversation with the folks who are doing the supervising on how they usually look at who is being successful on probation.
So
Yep, I can just throw out.
I'm sorry, Jeanette, I didn't know you hadn't finished your question.
Well, I just was going to throw out one more.
Broken up, or
Yep,
at
it's
least
frozen.
I've lost you. You're frozen.
Yeah, I've lost her too.
Okay. Joe, why don't you go ahead and then we'll hopefully get Jeanette back.
Yeah, Bryn and Sarah, the term that you're using is not consistent with the court documents. They're called probation conditions. And we probably ought to have that term used throughout, because everybody who enters into a plea agreement that has probation conditions that they have to comply with. And that's what the probation officer is actually supervising, those probation conditions. It's just to be consistent with how the court treats the language.
But isn't it part of a case plan?
There may be a case plan that is dealt with, but the court is using the term probation conditions. And that's the vernacular that the court is used to. I've never heard this term here of supervision, whatever it was.
All right. Maybe I would suggest that we take out the word actively for now and get an opinion from the Department of Corrections on what's the best way to describe the case plan or the conditions of probation.
I think that Judge Grierson would probably have a comment in this regard.
Yeah, I mean, we are working with a draft of the bill. I'm just suggesting that we leave it at case plan for now, for the draft.
Is this a good time for questions for Bryn, or do we keep going from here?
No, I can ask Bryn questions.
Bryn, can you scroll back to page 1 for a second? And go down to where changes are being made. And hang right there for a second. Discharging a person, this is line 19, discharging the person prior to the expiration of the probationer's sentence. I'm uncomfortable with that term only because it's technically the length of the probation. And I'm not sure that I've ever seen or heard the probationer's sentence.
Well, we can change that to term.
Yeah, I think that's probably going to be something that is more consistent with how the courts treat this. Because I'm not sure what the probationer's sentence is. Is it the 6 to 12 underlying, or is it the actual probationary term? And I think that changing it would be much clearer.
Okay.
Matt, can we, that's good catch, draft. Can we go back and agree to just drop the word actively? And use the term case plan, because that, I think we could talk to DOC when obviously they're going to testify on the bill.
Good with me.
Yep, it's good with me. I'm still not sure what a case plan is in this regard. I've never heard that term used in this area.
But that's the term that I used when I had kids on probation. They had a case plan within the facility.
I agree that in juvenile law, there is a case plan that is constantly reviewed. But as far as an adult criminal on probation, I've never heard that term used before.
Part of the problem with conditions of probation is that the Vermont Supreme Court made that determination that, had changed the terms and so forth on probation. I know that state's attorneys are not happy with that decision. You know what I'm talking about.
Yeah, I think we're on the same page in what we're trying to resolve. I just want to make sure the language is consistent with what probation officers actually understand.
For purposes of introducing the bill, I think we're fine with this terminology, and then Bryn can flag that with the lawyers over at DOC.
I will. I'll make a note about that.
Okay, thanks.
And there may be a little bit of I'm just going to say that I'll probably change the order of some of these sentences in this section. As I mentioned at the outset, this is a work in progress. So
yep.
It may not look exactly like this. For example, this sentence, the following sentence, which is that the probationer will not be considered ineligible for a discharge or for a term. The probationer has unpaid restitution fees or surcharges. That sentence is going to move down. I don't think it makes a lot of sense there. And then, so just to jump back into the walkthrough, what this next sentence provides is that if that probationer isn't eligible for dismissal because they don't meet the criteria that we talked about earlier, the department may move to request for a reduction in term for conditions completed or for goals attained.
Bryn, can I ask another question? The midterm review, is that something that you've spoken with probation about? I've never heard that term, only because I'm generally not associated with what happens internally once somebody is placed on probation. But I've never heard that term before. Is that something that's actually happening on every probationary case?
So it's supposed to be happening according to statute. And I can scroll up and show you the language that exists now. So there's a requirement in statute currently that the commissioner review everybody's, all probationers' records during the month prior to the midpoint of their probation term. And so I
Okay.
think it's generally called the midpoint review.
All right.
But currently it's may go to the court, and this would make it shall go to the court.
Correct.
I think that's the biggest difference here.
Right. This is sort of creating a presumptive process here that not only does the commissioner have to review the record, but they also have to file a motion if certain criteria are met. Okay, and then we're getting to the end here. This new subsection 2 says that if the commissioner doesn't file a motion pursuant to that section that we just looked at, or if the court denies the commissioner's motion, then it directs the department to conduct a review each and every 6 months following the midpoint review. So if the probationer has not been found by the court to have violated the terms in those 6 months prior to the review, and here's that language again, is actively participating in their case plan, then it just requires the department to file that motion requesting a dismissal of probation at this following 6 month review process. And again, you'll see the language here again, that if the probationer isn't eligible for dismissal for the remainder of their term, but has completed conditions or attained goals, then the commissioner can file a motion requesting a term reduction. And again, probationer is not deemed ineligible for discharge or term reduction if they haven't paid their restitution fees or surcharges. So that just sets up another process. So if the person isn't eligible for that first midpoint review process, it directs the commissioner to take another look 6 months later and file a motion at that point if the person is eligible.
I asked a question about that particular provision. What happens to those owed fees, surcharges, and restitution, particularly restitution?
If they're unpaid and the person is
Released from probation, what we have to ensure compliance with that provision?
Yep, I don't know about that. I know the person remains responsible for paying their restitution, but I understand that you're saying that they no longer have that.
I'm actually more concerned with restitution than fees or surcharges at this point. I know that to get expunged, we've been dealing with the fees and surcharge. I'm just worried about not paying restitution and how that impacts the person's responsibility to accept accountability for whatever they might have done.
Right, so that would be a good point to raise with the court administrator, I imagine.
Yeah.
And Senator Sears, can I just ask a question on that?
Sure.
Why on that would not the word get around that, hey, in reality, you don't have to pay these if this is a part of it? Why wouldn't just word get around and say, hey, this isn't going to be one of the requirements, so don't do it? Don't pay it. Why wouldn't that word get around that but basically you could skip it.
Sarah, in other states, have they done this?
Well, I would say at large, the concern is that if all financial obligations have to be completed in order to earn discharge, you're setting up discharge by class system. So people who have no financial resources are not going to be able to earn time off incarceration, and people who come from, wealthier backgrounds are able to earn time off their sentence. So there is there's a concern there around equity and financial backgrounds on, people not wanting essentially to set up a system where people can be good and that people aren't able to shorten their terms because they're from poor backgrounds. But I mean, I believe that, or for sure, this should not mean that people have their financial obligations dismissed. But I do understand that there could be a concern that, well, if they're not regularly seeing a supervision officer, then are they going to actually feel obligated to pay them? So I think there is a push-pull there, but I would just, I would say that the concern coming from me personally is, does that mean that if you're poor, you can never earn time off your sentence because you have all these financial fees, fines and fees hanging over you? And there is a lot of research nationally on how fines and fees specifically related to the criminal justice system really impact people's ability to successfully re-enter and re-enter the community. So that's there. I think I can see that restitution could be definitely treated differently, and that could be a point of conversation. But that's what I would note there, and why I would encourage you all to definitely think really deeply about financial obligations and how they impact certain people more than others.
Mhm.
Yeah, I see what you're saying.
I would prefer to have restitution taken out of there and put a second sentence in there regarding restitution, something to the effect that the court may seek alternative for the restitution, but shouldn't. I just like to have that flagged. I think restitution is different than fees, and I would have. Don't we consider restitution? Maybe I'm not understanding something, but I thought we considered the offender's ability to pay on restitution. Maybe making the offender have a plan to pay off the restitution or something like that. Anyway, flag that. Joe?
Yeah, are these fees and restitution subject to a tax intercept for failure to pay?
I think so.
I know restitution is, I'm not sure about the fees. I'd have to check on that.
Okay, maybe we should just do restitution separately to make clear that they would pay it under a tax interception. That may be made clear to the individual that they're not, that the court is not necessarily waiving those. I'm really I'm much more concerned about the restitution.
Senator Sears,
Yeah.
can I just say that I have no idea what's going on here, but it keeps kicking me off the Wi-Fi.
Wow.
So I've been absent for a while, and then I have to log back in, and I don't know what's going on here.
Well, I think you need help from IT, but I just had to invest another $40 a month in a better Wi-Fi. So if you want to call your internet provider, be prepared to sign up for an extra $40 a month for Wi-Fi.
Well, they just switched to Xfinity from what we had, so.
Okay.
Okay,
Anyhow,
but I just wanted you to know that I'm not purposely leaving.
I hear you. And thank you for staying with us. All right. I don't know who's just joined us. Ness.
How do we say how we joined?
I don't know.
Anyway, can we, any thoughts on the restitution piece?
I agree with you that setting up something a little bit different for the restitution piece would be good. I understand what Sarah's saying, that it's an issue of equity, that some people would never get out, but you never get off.
Well,
But still,
if someone continues to owe the money for restitution, but we allow them to get off their sentence, it seems to me that we haven't relinquished their responsibility. The tax intercept is at least one way to get that money. I'm not at that point. You can't get blood from a stone. So if they don't have the money, then when they get out of prison is particularly bad time to demand it of them. So I like the way it's written, I guess.
There is a restitution unit that is charged with the responsibility of making collections.
Mhm.
I don't think that's part of probation's responsibility anymore, although I haven't thought about this in a long time.
Well, I'm
So-
willing to let it go like this, but with the understanding that it's going to take a little more research into how we deal with restitution. I always thought that we had a ability to pay matter with restitution
We want to talk.
when it's first set, don't we?
Yes, when it's first set, but that's subject to review by the court. And I believe it's the restitution department that would bring that petition, not probation.
Peggy, at some point during the discussion of this bill, I think we're going to need to hear from is it a restitution unit within the Center for Crime Victim Services, or is it a
Correct.
restitution?
It's called the Vermont Restitution Unit, and it's within the Center for Crime Victim Services.
Okay, well, I'd like to hear from them when we, at some point, when we take up this bill to better understand the restitution. I'd say leave it in the way it's written now and the way the draft is, with an understanding that we'll take a good hard look.
And I would just note that there are avenues for people who are having trouble affording their restitution payments to return to the sentencing court and get a different arrangement for their payment plan.
I mean, I understand everything Sarah and Philip have said, and I totally agree with them. On the other hand, when you take this plea agreement, you have agreed to make restitution, and that's part of the obligation, part of taking responsibility for whatever you might have done.
Dick, if I'm correct, and probation is no longer supervising the collection of restitution, you may want to talk to somebody from probation as well, because effectively this would be placing that question back into probation to deal with.
So the restitution unit is the only unit that's responsible for collecting restitution payments. It's the court that has to collect the fees and the surcharges.
I think so.
And I will note that that restitution would remain even if the person was released from their probation supervision. The restitution order would remain, and the restitution unit can enforce that order as a civil judgment. And they can do that by wage withholding, property liens, attachment and sale of assets, suspension of recreational licenses. And then if there's a refusal to pay, then they are subject to civil contempt proceedings. So
Yeah, I would say based on that I'm leaning in favor of eliminating restitution from this bill, simply because you're going to require probation then to come back and be monitoring the restitution payments. And I'm not sure they'd want to take that responsibility back on now that there's a restitution unit doing it for them.
I think the wording here online, I think I have a different page number structure when I printed it off this morning, but I believe that the wording is that a probationer shall not be deemed ineligible for discharge or term reduction due to unpaid restitution fees or surcharges. So it takes probation out of it, I think. They've released the judge would then release the person from probation based on everything else. And then the restitution unit would take over if the person fails to pay their restitution. It could result in a civil judgment, contempt of court, or whatever. That way I'm hearing you, Bryn?
yes, that's how I'm.
Well, I think we leave it in.
Yeah, it doesn't change the status quo on that, does it?
No.
It just says it can't be used as an excuse to deny somebody access to this.
We just finished the walkthrough. I think we're at section 3 of the reports.
Sure. So as Sarah mentioned this morning, because there's not data, there's no existing data on how these midpoint reviews are panning out for people. This is a directive to the department that they begin to collect data on the midpoint review process a year after this section would take effect. So that would be the number of probation discharges or term reductions, the number of motions that are filed by the department to either discharge or reduce the term of probation, the number of probation terms that are reduced or terminated, and the amount of time that's reduced from probation terms as a result of these motions that are granted by the court. And then it requires 2 reports by August of 2022 and August of 2023 by the department to the Justice Oversight Committee with the data that they've collected and any recommendations for further legislative action.
Great. Any other questions for Bryn or Sarah on this particular provision? If not, we're going to take a break until 10:30. And at that time, we'll come back and take up S18, which is the earn good time, and hear from family members of some victims. And then at 11, we take up S7 again, which is the expungement. So we'll take a break till 10:30. Thank you.
Hopefully I'll be back.
Now, hopefully you can get your technological problems fixed. And thank you so much, Sarah, for joining us this morning. We really
Yeah.
appreciate
Yes.
it.
Thank you, Sarah. Nice to see
Thank
you.
you.
Good to see you. We'll see you again
Great to
soon,
see
I'm
you all.
sure.
Thanks for having me.
Okay,
Thank
great.
you.
So we'll take a short
We can start whenever you like, Senator. We're still live.
Okay, good. My agenda, and as Taylor Fontaine is our first witness, and followed by Pamela Fontaine, and then Ed Winterbottom and Joanne Winterbottom. So if we could follow that. This is on S18, the bill dealing with earned credit for good behavior. And those of you who we've dealt with this last week or earlier this, I can't remember what week we're in already. Taylor, welcome to Senate Judiciary Committee. I'll introduce the committee members for you and all the other three witnesses, and then we won't need to do that again, but thank you for joining us. I'm Dick Sears from Bennington County. I chair the Senate Judiciary Committee. Phil, maybe you could go next, and then.
Good morning. I'm Phil Baruth. I'm Senator from Chittenden County.
Joe?
Good morning, State Senator Joe Benning from Caledonia County.
Senator Nitka?
Alice Nitka from Windsor County and some other towns.
Senator White is having technical difficulties this morning. Are you there, Senator White? She's been having technical difficulties in getting into the Zoom this morning, but sure is listening. She's from Windham County. Taylor, please go ahead.
Hello, everyone, and it's excuse me, very nice meeting you. Thank you for allowing me to speak in front of you. Sorry, today regarding Senate Bill 18. My name is Taylor Fontaine. I am an elementary school teacher. I am a friend. I am a daughter. I am a sister. I am a girlfriend. I am a coworker. I am a volunteer. I am a student. And among all these things that seem normal for my age, I am also a victim. I was 12 years old. Excuse me, this is still very hard for me. I was 12 years old when I was drugged and molested by Robert Kolobos at a sleepover at his house after a middle school dance. I was 13 years old when I testified in front of a filled courtroom on the most vulnerable time of my life. After hearing all 12 jurors say the man that turned my whole life upside down was guilty of the crimes he committed, my whole body shook and tears streamed down my face. I was so relieved. He could never violate me again or anyone else for a very long time. But I would still have to live with this for the rest of my life. An adult made the decision for me as a young girl to change my life forever in one of the worst ways. I struggled. And I mean, I really struggled. I was trying to live the life of a normal teenager and now young adult while functioning with trauma. Trauma created by Robert Kolobos. I remember getting the call about the current good time rule being enacted. I was sitting in the school library during my planning time. I was confused at first because I had never heard of the good time rule. As I learned more about what it meant, my heart sank. I was assured by his guilty verdict that he would be in jail for a very long time, and that my bravery at such a young age helped put an evil man behind bars. I relied upon his sentence to be able to try and heal to the best of my ability, knowing I wouldn't have to worry about him. All the wounds from the trauma I thought were starting to heal were cut open once again. The big question here is why the new changes proposed to this bill should be there. I want to reiterate that the one relief that I got was he was going to be in jail. He wasn't going to do this to me again. He wasn't going to do this to anyone else. I couldn't run into him for years to come. It was the one relief I got from something so traumatic. The one relief. An argument that I keep hearing over and over again for the reason this bill shouldn't be passed is that people change. And yes, people can change. But what doesn't change is the trauma endured by a victim. The trauma I endured at such a young age. The trauma I am still going through as a survivor of sexual assault. This coming May, it will be 13 years since my assault. 13 years later, and I'm still dealing with it. Why should he have the ability to get out of jail earlier because of good behavior? He committed a crime, right? He was found guilty, right? The trauma doesn't end for me, and unfortunately, it never will. I don't have the luxury of behaving the way I'm supposed to so that my trauma goes away earlier. I don't have the ability to reduce my survivor sentence. I sit in front of you today to share my story and advocate for victims like me, now and to come, in passage of the Senate Bill 18. I am hopeful that the right thing will be done to protect survivors like me. Thank you again for allowing me to speak in front of you today.
Thank you very much.
Thank you, Taylor, very much for the testimony. Are there any questions for Taylor? My only question is, what was the minimum sentence provided to the perpetrator?
For the
You know?
ludus lascivious, it was
Yeah.
12 to 14 years.
12 to 14 years.
12 to 14? Thank you. Pam Fontaine, are there any questions for Taylor? Pam, did you want to testify?
Yes, please.
Sure.
So, hello, I'm Pam Fontaine. I'm Taylor's
Pam.
mom. Sorry, it takes me a second because this brings back, just talking about this stuff brings back so much for Taylor and for our family.
Thank you so much for your bravery, and both of you coming forward. I know it's not easy.
Thank you, Mr. Sears. I appreciate that. I actually want to start by saying that Taylor's bravery has helped so many people to be safe from a very dangerous man that was in our community. Taylor is a very courageous, loving and caring, intelligent young lady who has worked very hard within herself to find the peace and the strength that she needed to overcome being a victim to becoming a survivor. I am very proud of her and her power and her strength. I'm a parent. Can you imagine the moment you realize someone has hurt your child? I never thought I'd experience what I did that night after Taylor called crying and said she was scared, asked me to please come get her now. I'll never forget when I realized something more just happened to her than thinking she was just scared. Can you imagine that moment? This story started with a phone call to me from Robert Kolobos himself, asking, can Taylor sleep over after the dance tonight? What was about to unfold was not supposed to happen, not to my daughter, not to my family. Robert Kolobos was charged with lewd and lascivious conduct with a child and unlawful restraint. He drugged and molested Taylor. Can you imagine that? If I told you the whole story from that phone call to today, we'd be here for quite some time. Taylor's been through a lot. Our family's been through a lot. When Taylor just mentioned that she struggled, she struggled. It was real, it was hard, and it was strong. The trauma, the PTSD was like a volcano, is all I can explain. Sometimes erupting in small spurts, and other times like a full-blown blast. We were her family, and we struggled and erupted right along with her every single time. Even to this day, when Taylor struggles. Taylor's sentence is embedded into her, an event that she cannot erase. One that she cannot have reduced for her good behavior. No matter how hard she works, no matter how many counseling sessions she goes to, no matter, no matter how much she contributes to society, she's a good citizen who deserves a sense of security and peace every day, all day. So we came here today in hopes that you will see and know that the Senate Bill 18 should come to passage to protect her and all of the other Taylors in the world. Because there's more of them. I'll pray for you to make a mindful decision and not rush to do so. So many current and future victims deserve to be protected and to feel that their rights are considered first and foremost over their perpetrators' rights. Thank you all for your hard work and for your consideration and for listening to us today.
Thank you.
I'm sorry, I muted myself. I wanted to thank you for your testimony and asked if there's any questions from the committee. Thank you both so much for testifying today. And I can only imagine, I can't say I know how difficult it is. I can only imagine the best of both of you as you seek recovery from this.
Thank you.
Senator Benning.
Taylor and Pam, I want to thank you as well. I also want to say that I'm a criminal defense attorney for 37 years now, and I've never heard the term a victim's sentence. That is a really powerful statement, and it is one that I promise you we will all take into account in trying to deal with this bill and put out something that makes sense. So thank you very much for testifying.
Thank you.
Thank you.
Thank you for those words.
Mr. and Mrs. Winterbottom, you're next. And so I don't know which one of you wants to go first. But, I have Ned first and then Joanne, but it's up to you all. I think you're muted, sir.
Yeah, I'm trying to unmute them.
Oh, you muted them.
I did mute them, and now I'm trying to unmute them.
I think we
Oh, I
succeeded.
think we got it. Thank you.
Thank you for joining us this morning, Mr. and Mrs. Winterbottom. Really appreciate it.
Good morning.
Good morning.
My name is Ned Winterbottom. I'm the father of Laura Kate Winterbottom. I'd like to thank you for the opportunity to testify to you today on Senate Bill 18. My family and I support this bill. We want to especially thank Attorney General T.J. Donovan for his support and his integrity. Commissioner Jim Baker for really listening to us. Senator Sears for sponsoring the bill, and for all the committee members who are willing to be open to reconsidering earned good time. While we recognize the need for prison reform, we strongly object to the application of earned good time to rapists, murderers, and pedophiles in the Vermont prison system. We can understand and even support some of the goals of justice reinvestment. The more we learn about this subject, the more we understand that these are complicated issues that you guys have to struggle with, and that sometimes in trying to solve one problem, perhaps another one is created. We appreciate the fact there's a willingness to, at this time, to listen to victims' voices and to revisit the issues associated with earned good time, keeping in mind the perspective of victims. Our daughter, Laura Kate Winterbottom, was kidnapped, raped, and brutally murdered, and I mean brutally murdered, in Burlington on March 8, 2005 by Gerald Montgomery. Because of the brutality of this crime, he was charged with aggravated murder, which carries a sentence of life without parole. A plea agreement was negotiated under which he would plead guilty to first-degree murder and receive a sentence of 43 years to life. The prosecutors informed us that if the plea agreement was not acceptable to us, they would pursue the charge of aggravated murder at trial, and because of the DNA and other overwhelming evidence, their case was very, very solid. We were advised that the trial would involve making all public all the graphic details of the extreme brutality inflicted upon Laura, and also are enduring the ordeal of listening to Montgomery's counsel attempt to defend his savage, undefensible crime against her. We were assured that 43 years was a minimum Montgomery would have to serve before becoming eligible for parole, and that he would have to successfully complete a course of treatment for sexual offenders before he would be eligible for parole. We were not told about earned good time because it did not exist at the time. We obviously were not told that 15 years later, the 43-year minimum would be retroactively changed without adequate notice to potentially dramatically reduce it. This was a very painful and difficult time for us, and we were in deep and profound grief over Laura's death. We relied heavily on the representation of the state's attorney's office and the Burlington Police Department, both of whom were actually wonderful, and we trusted them to seek justice for Laura and act in our best interest. After much deliberation and in reliance on those representations, we agreed to accept the plea agreement. The rape and murder of our Laura were savage crimes, and in deliberately committing them, we believe that Montgomery forfeited his right to any reduction whatsoever in his sentence. We learned during the course of hearings that he had previously sexually assaulted at least 2 other women that we know of. When he took Laura's life, he permanently changed the lives of everyone in our family in profoundly irreparable ways. I agree with that term, victim's sentence, and that's what we have. Laura is no longer, she has a lifetime sentence. She lost her life. Her sentence was death. There is no such thing as healing from the death of a child, especially a death like Laura's. Life is never the same, but you carry on. It was, however, very important for us to know that Montgomery was safely behind bars for at least 43 years. And therefore, we could turn our focus not on him, but rather on preventing the type of crimes he committed. This certainty helped us to establish the Laura Kate Winterbottom Memorial Fund, a Vermont-based foundation with a mission of ending sexual violence and helping survivors. To date, with the support of thousands of people, the LKW Fund has raised and donated over $225,000 to organizations in Vermont and programs that support that mission. What we can determine from review of the legislation and the Department of Correction report on the legislation entitled Availability of Good Time dated 12/15/2019, there are 2 primary reasons advanced for the retroactive application of earned good time system that alters the sentence and plea bargain for currently incarcerated offenders. 1, the claim that increased participation, this is a quote, increased participation will have a greater impact on prisoner morale and behavior, close quote. And 2, a need to avoid, quote, increased administrative burden, close quote. We submit that neither reason is adequate to justify a system which effectively alters the plea bargain minimum sentence of a brutal murderer and has the potential to release a violent, repeated sexual predator and murderer back into the population 6.5 years short of his minimum sentence. The report of the United States Sentence Commission to Congress from 2016 to 2019 for federal prisoners shows that violent criminals and those with a serious criminal history are at a significant risk of repeated crimes with a recidivism rate of over 80%. A Bureau of Justice study has shown that 10% of released murderers in 30 states commit another crime within 6 months of release, and 48% commit another crime within 5 years of release. The 2019 U.S. Sentence Commission report on recidivism among violent federal offenders shows that even released offenders over 50 years of age with a serious criminal or violent history have a 37% chance of committing another crime within 5 years of release. This means that during the 6.5 years that Montgomery could potentially be released earlier than his minimum sentence, there is an over 37% chance he will commit another crime. Given his history of violent sexual assaults and murder, there is a significant risk that he will rape or possibly murder another woman. That is a risk we are not prepared to sanction on the basis of prisoner morale or avoidance of an administrative burden. And we don't think the state of Vermont should do that either. While we understand the goal of making a criminal justice system more fair and a correction system more humane, we also believe that there are offenders in the correction system, such as rapists, murderers, and pedophiles, whose criminal thinking, history, and propensity for violence make them a dangerous society and a significant risk for future crimes. Many such offenders are violent psychopaths or sociopaths, people for which psychologists tell us there is little, if any, possibility of significant positive change. We have heard Senator Sears at a previous hearing of the Joint Legislative Oversight Committee say that we should lock up people who are dangerous, not those who are a pain in the neck. We agree. We assert that the corollary to this statement is that we shouldn't release early, before they have completed their full minimum sentence, those offenders who are truly dangerous, like Gerald Montgomery. He must need to serve his full sentence, because that is as it should be, considering the severity and barbarity of his crime, justice for Laura, and the genuine concern for the protection of society demand nothing less. Thank you.
Thank you, Mr. Winterbottom. I appreciate it. How difficult it must be for you to testify here today. I appreciate the thoroughness of your remarks. Are there any questions for Mrs. Winterbottom?
Thank you. I'm Joanne, Laura's mother. Oh, James.
No, you're fine.
Oh, okay.
That
So,
was somebody else.
first I want to thank you for this opportunity to testify on Senate Bill 18. We appreciate this opportunity more than we can possibly express. I'm fully in support of this bill to amend earned good time. Our daughter Laura was abducted and over several hours repeatedly raped and sodomized, and then strangled manually and bludgeoned to death with a wooden board by Gerald Montgomery in Burlington on March 8th, 2005. As Ned had mentioned, Montgomery was initially charged with aggravated murder. And on the advice of the state's attorney's office, and after much deliberation and in good faith in the integrity of the Vermont judicial system, we agreed to accept a plea agreement. Montgomery pleaded guilty to first-degree murder and accepted the sentence of 43 years to life imposed upon him by Judge Coopersmith. In support of Senate Bill 18, I would like to make 5 points. 1, the state of Vermont should be ethically and judicially obliged to honor the agreement it made with us in imposing Montgomery's sentence. Attorney General T.J. Donovan has made it clear that he is in agreement with us in regard to this issue, and I and my family are grateful for his acknowledgement of this agreement and applaud his integrity. My second point is that violent offenders and murderers should be excluded from earned good time. In his attack on Laura, Montgomery actually committed 3 distinct crimes: abduction, rape, and murder. His violation and bludgeoning of her were deliberate, vicious, and merciless. The willfulness and savagery of his crimes should negate his right to any reduction whatsoever of his sentence. Moreover, we learned during the course of hearings that he had previously sexually assaulted at least 2 other women, so he was in fact a repeat offender. My third point, in the meeting of January 13th of this year, 2021, to consider amending the policy, the issue of the indelicate method used to apprise victims and their survivors of the policy was raised, as well as the consideration of changing the insensitive name of the policy.
While these assuredly need reconsideration, my focus is on Senate Bill 18 per se. Fourth point, in response to the comment made in the meeting of January 13th that people can change, I respectfully submit that there is no unanimity of opinion among experts in the scientific community that all people can change. It is a complex issue involving many factors. In regard specifically to violent sex offenders like Montgomery, there is overwhelming evidence that they do not change their proclivities and behavior. The recidivism rate for sex offenders is very high. Montgomery, in fact, as we've mentioned, is a repeat offender who progressed from sexual assaults to murder. Releasing him into the community before his full sentence is served is an assault on the principles of truth and justice that are cornerstones of an optimally functioning civilized society. An early release poses a risk that should not be sanctioned. And my fifth point, in response to the testimony given on Friday, January 15th, I am feeling that while there was verbal acknowledgement of the rights of victims, there was more concern with the rights of offenders. Words like disparity and inconsistency and statements regarding potential litigation around perceived unfair practices and statements regarding potential complications around plea agreements were stressed, and each in reference to offenders in conjunction with the proposal to amend earned good time. In my opinion, an emphasis on the rights of offenders constitutes a gross and egregious imbalance of justice and power. In our particular case, the reality is that Laura is a victim with absolutely no rights or power at all. Her voice cannot be heard. She is dead because heinous crimes were committed against her. We, Laura's family, are advocating for her and urging the passage of Senate Bill 18. The current earned good time policy, as it would apply to our Laura's murderer, disturbs us to our core and makes us feel re-victimized. When Montgomery ended Laura's life, he forever changed my life, my husband's, my daughter Lee's, and my son Aaron's. We, in fact, are serving a relentlessly painful lifetime sentence. Allowing him to qualify for an earlier release is not acceptable to us, and it is certainly not in the interest or pursuit of fairness and accountability. Our request is simple and threefold: that Vermont honor the agreement it entered upon with us when Montgomery was sentenced, that he not be given the privilege of eligibility for good time, and that Senate Bill 18 be passed. And thank you again for allowing me to express my opinions.
Thank you. Appreciate your thought. Senator White has a comment or question.
I just have a question, and I appreciate very much all of your testimony and how painful not only the acts were, but how painful it is for you to relive them now by testifying to us. So thank you very much. My question is, when I'm looking at S18, is that there are a number of disqualifying events in there, and one of them is manslaughter. So I guess my question is, do you support the bill as it is with all of the disqualifying events, or would you be more focused on certain crimes that should not be given good time?
Well, I would speak for myself, which is that I'm speaking about our case. I don't purport to speak for all victims. There may be victims of manslaughter who feel like we do too, but we're not in that place. I mean, when we first heard about Earned Good Time, a lot of people contacted us and wanted to talk to us about it. And we basically said, talk to Crime Victim Services and maybe your voice will be heard. we want to speak for ourselves about that issue. I know Attorney General Donovan was instrumental in putting that list together. I have a lot of faith in him. He's a good man, and if that's his judgment, that's his judgment. I wouldn't question it at all.
Thank you.
Anyway, we wouldn't purport to speak for other victims. I agree with what Ned has said.
Thank you.
Just to make, and I know we're clear, just to make clear, for those who may be also listening, when we use the term retroactive, people who were sentenced do not earn good time, would not earn good time for a period already served for January 1st, 2021. So just to make clear that the term retroactive, some might mean that they were going all the way back to the sentence. It actually begins January 1, 2021. If this bill passes, that would end. They would not earn the good. Those folks would not earn the good time. But nobody who was currently incarcerated prior to December 31st, 2020 would earn any good time. I don't know if that was, I hope that's clear to those that may be listening.
For us, Senator, we were clear about that. What we meant was that.
No, I know you were, but when we use the term retroactive, people might think that he would have earned good time for the 15 years he already served prior to the enactment of the bill. I just wanted to make that clear to anybody who's listening. I think you were very clear about it that it started. Okay. I thank you, all four of you, so much for joining us today, and I really appreciate your testimony. It's very important to us to hear all sides. I will say that some of the offenses listed here, I think the biggest concern is that we not end up with unintended consequences of someone who, due to an age gap in some of the offenses, and that was simply why they were charged. I think that was some of the subject last week that people were looking at. With that, I thank you very much. Are there any other questions for any of the four witnesses? Thanks so much again.
No, thank you for coming forward.
We will continue to work on S18 next week. It's a priority for us. It needs to be one of those bills that we get passed as soon as possible.
Thank you. We appreciate that.
Thank you. We're going to move on now to a different subject, and that's expungement. S7. And our first witness on S7 is representative from the State's Attorneys and Sheriff's Association, James Pepper.
Thank you. For the record, James Pepper from the Department of State's Attorneys and Sheriffs. And if I could, I'd like to just speak very briefly about the origin of this bill, and then talk about expungement more generally with respect to the state's attorneys, and then just discuss some of the specific concerns that were raised with respect to this bill. So the origin of this bill, in 2019, the legislature passed Act 32, which was an expungement bill. It expanded expungement to a certain number of crimes and made some other tweaks to the statutes. And at the very end, it directed the Sentencing Commission to conduct a comprehensive assessment of the statutes governing expungement and sealing, and propose to the General Assembly improvements to the expungement and sealing process, as well as additional civil or criminal offenses that could be eligible for expungement or sealing. So the Sentencing Commission put together a subcommittee that is responsible for a lot of the substance of the bill before you. And, you know, it did pass, I should say, the Senate last year, and it did not get taken up in the House. So moving to the state's attorney's comments, more generally, the state's attorneys are very supportive of expungement. There are, of course, huge benefits to people who are unemployed or underemployed. There are huge benefits to people that are seeking professional licenses, public housing, certain educational opportunities, military service. Of course, we've heard that usually potential employers, landlords, et cetera, often use criminal history records as a proxy for dangerousness. Really important to the state's attorneys also is that expungement can correct historical, geographic, and racial disparities, and can offer a path to full redemption to people who, may have really turned their lives around. Importantly, the vast majority of convictions that are the subject of expungement petitions today are for crimes that, had they been charged today, they would have been sent to diversion or presumptively sent to diversion or had deferred sentence eligibility, meaning that they would have never resulted in a criminal conviction had they occurred today. So the state's attorneys, for all of those reasons, are very supportive. However, they have raised some specific concerns with respect to this bill. And really those fall into three sort of broad categories. The first is that this bill is a complicated bill. It really exacerbates some of the complexities of our current expungement statutes as opposed to simplifying them. One of our deputy state's attorneys, in advance of a expungement clinic with legal aid, tried to create a very simple flow chart for the people at the expungement clinic to determine whether they were eligible for expungement. And the flow chart turned into 15 pages that really kind of laid out the various categories of offenses, the eligibilities depending on the age of the offender at the time that the offense was committed, the disposition of the case, and of course, any number of various timelines that exist in the expungement statutes. And this bill adds a layer of complexity to what is already a complicated area of the law. And one other concern that was raised by Judge Grierson at the previous testimony is that many of the proposals in S7, they perpetuate this kind of two-step process that we have in Vermont, where you're eligible for sealing at one point, and then a few years later, you're eligible for expungement. And of course, that two-step process requires two petitions. It requires two sets of review by the state's attorney and potentially two hearings. So that's the first kind of broad category of concern that was raised by the state's attorneys. The second is that the permanent deletion of records makes certain people in law enforcement and the state's attorneys uneasy. I know that CRG, for instance, Crime Research Group, uses court data and police records to evaluate trends over time and to help establish baseline data. And I think about, I tie this sometimes to the marijuana issue, where in Colorado, they really wanted to see what the impact of tax and regulate was going to be on certain things like traffic violations. If we are permanently deleting records with no ability to retain them or to analyze them, then it can be detrimental to forming that baseline data. Police reports often contain information about third parties that might become relevant to subsequent investigations. And of course, defendants and victims sometimes want to access information that was in their expunged files years later for various reasons. And I would just reiterate a point that was made earlier, that we're in an extreme minority of states that actually treat expungement as the permanent deletion of records. Most other states have a sealing process, and then there's the real conversation turns around who has access to those, whether law enforcement can have access to them or not. And so, that's, to me, or to the state's attorneys, a much more effective use of expungement and sealing. The third.
Can I interrupt before you go to the third? This whole idea of, I don't know, every time I put my glasses on to the computer and that caused the thing to bounce. Can you hear me?
Yes.
Oh, okay. I get confused between sealing and expunging. And when we first did this, way back when, maybe that's when we messed it up, but I never attended them personally. And I was one of 30 senators. But I don't think the intent was to completely get rid of every record that might have existed. I think at the time we talked about the fact that there might be newspaper articles, there might even be, I don't even know if there was social media then, but it wasn't very active. But there might be newspaper articles or whatever that was still there. And we knew we couldn't expunge or seal every record. And it's not clear to me the difference between expunging and sealing still to this day. And we've been dealing with this for years. But the goal here is for the person who has worked hard, shown that they have changed their lives around, that they have not been in any trouble for a certain period of time following whatever offense. And as you said, many of them were offenses that if they were committed today would never even get to court. They'd be pretrial diverted. So that was the idea. And I don't know where this idea that we had to go into every record and destroy it.
Well, so you are right. I mean, the kind of fallacy of the expungement system is that these records do carry on in various forms, whether they're expunged or not, through these data scraping and data warehouse companies, and they're purchased by insurance companies and others, whether they're expunged or not at the time. So, really what, the sealing is just a segregation of the files with, and it's allowed to be used for certain distinct purposes. The expungement is the permanent deletion. And if there's an expungement order and it's processed by VCIC, 1 minute before the expungement order is processed, it will show up on a background check. The second that they hit delete, it's gone forever. And I think that the benefit to sealing and expungement is relatively the same, which is that the person who's the subject of the record can say truthfully that no record exists, can respond to that on a job application or a housing application. And really, I think that what we need to move to is a system that allows for the sealing of records, and over time, the people that have access to those sealed records diminishes. And law enforcement currently is allowed to use sealed records for any legitimate law enforcement purpose, but maybe after a certain number of years, that should fall away as well.
And so it started for me with the juvenile sealing statutes, where juveniles who were maybe accused of committing a crime 10 years after, when they were 30 and had been in juvenile court when they were 16, that was then coming up because somehow the police still had access to those records that were supposedly sealed. And those kids were told that they were sealed at age 18. That's where part of my confusion about sealing and expunging comes in. And as you said, maybe the discussion should be who has access.
That's the direction that the state's attorneys, and certainly it sounds like the court administrator, have been advocating for. And there's probably good arguments on the other side, but to me, the permanent deletion is something that is one of the major concerns that has been raised by the state's attorneys with respect to expungement.
Joe, Senator Benning.
So Dick, we first started all this in 2011 with what was then S37. And my motivation for being there at the time was I had a question on the application for the bar exam of whether I had ever been arrested. And pursuant to New Jersey law, the expungement process that I went through, I was legally authorized to say no, which is not what I did on the application. I actually explained what I'm explaining to you right now because I didn't want there to be a problem. But it's not a question of who has access so much as it is the ability of the individual involved to be able to say no to the answer of that question when they've gone through the expungement process. And I don't know that we need to get hung up necessarily on who has access to it, as long as whoever has access to it is not allowed to release information about what they have access to. And I don't know, James, if you've thought about distinguishing it in that way, because limiting those who have access would, to me, be the target that you're trying to achieve, with specific instructions that they are not allowed to release that information to anyone, period. With brief exceptions, for instance, creating an amalgamation of data for looking back in time over what's going on in Vermont. But at the end of the day, the individual who is involved should have absolute authority to say, no, I've never been arrested or I've never been convicted.
It's absolutely where the state's attorneys are as well. And I think that is available to both sealing and expungement. If you look at the statutes, I think it's 7606 and 7607 about the effect of sealing, the effect of expungement. In both instances, the petitioner who's been granted an expungement is permitted to say, when asked, no record exists, and the court or anyone who owns those records or is the custodian of those records, when asked, also has to say no record exists. However, the difference with sealing is there's this exemption for law enforcement to use certain sealed records for legitimate law enforcement purposes, subsequent investigations, and any legitimate law enforcement purpose. But yes, that's exactly the system that we would envision as being a lot more. It would address this concern that's been raised.
Well, at some point we could look at language on that.
Okay.
Senator White.
So could you, Pepper, could you instead limit the, if law enforcement has it for legitimate purposes, are the legitimate purposes defined? And could you define them and address Senator Sears' issue about juvenile records, that they can't be used, juvenile records cannot be used for, there's no legitimate purpose for those. I mean, can you?
But they have.
In sealing, could you define it so that you don't have to have the two-step process and yet make it clear that it can be used for some things and not for others?
Absolutely, you can do that. And I think legitimate law enforcement purposes, I believe, is defined in statute. And you're right that the exemption for law enforcement use of sealed records applies strictly not to juvenile records, but records sealed through the petition-based system in the criminal statutes. So the juvenile statutes are dealt with in a separate title.
Right, but my point is they're supposed to be sealed, and I'm not sure they are. Senator Nick.
So I just, I mean, legitimate law enforcement purposes, just as Jeanette said, sounds so broad. I mean, I don't have the definition of what that is, but it seems like that's almost anything that law enforcement might be working on. And therefore, just that statement is not enough.
It is broad, but again, there is this shield from public disclosure. So it is a legitimate law enforcement purpose. However, if a law enforcement officer wanted to use a sealed conviction as a, for instance, for a DUI that has been sealed for a subsequent DUI, they would have to go through the process of unsealing that before they could actually make it publicly available.
Going back on this.
I don't know.
Is it not?
I would think that piece would need to be somehow modified.
I think we dealt with that in the when we did the DUI, because it's only sealing, it's not,
Right.
it's not expungement on DUI.
Yeah,
Anyhow, we interrupted your flow. I want to make sure we can get to Erica.
So I'll just, the final concern, and this is kind of a victim of our own success kind of concern, is that there is a administrative cost to this bill. I spoke to VCIC yesterday, the Vermont Crime Information Center, about just the pure numbers of expungements, and it's incredible, actually, the work that's been done through legal aid, through this committee, through the General Assembly generally. And in 2018, there was 2,500 expungement orders, 2,503. In 2019, there were 7,700 expungement orders that they processed. In 2020, there was 14,739. And there's only one person at VCIC that actually is able to work on this. It's a full-time job. From the state's attorney's end, each expungement petition to kind of navigate the qualifying offenses versus disqualifying versus timelines takes approximately 30 minutes, and also to attempt to contact a victim. And this bill represents a huge expansion to eligibility. So we would expect there to be a huge increase in the number of petitions. So in the past, when we've looked at, what was it, Act 32 in 2019, what we did was we looked at how many historic convictions there are for all of the new offenses. And we've estimated an uptake rate, because obviously not everyone who's eligible will actually petition for expungement. But we've estimated an uptake rate based on previous expungement expansion bills. And then we've just calculated how much time this bill will require to implement. And of course, timely and accurate implementation of this bill is incredibly important, especially when you're talking about expanding it to any number of felony convictions.
Okay. Well, if people want to have JFO involved and come up with figures for what it will cost, we can always add it to it in here. I can't guarantee you the appropriations committee is going to see it as that priority for the different parts of the system.
I recognize that. I mean, I understand, with justice reinvestment and kind of the appropriations that they're seeking in that working group. I can understand the kind of competing for limited resources, but I had, it's one of the major concerns that the state's attorneys raise when they look at this bill. And again, generally they are.
Happy to look at an estimate from the judiciary, the defense, and the prosecution. Is there anybody else that's involved?
Well, VCIC is, they're the ones that are actually going through the records once the order is done and making sure that they're either sealed appropriately or expunged appropriately.
We'd be happy to look at estimates of cost for the Department of Public Safety as well as the other three. However,
thank you.
If we could just settle on, my understanding of part of the cost involves the expungement process that the court has undertaken, which was to go through every record that existed. And if you seal, you don't have to do that, as my understanding.
That's right. I mean, all of my testimony is kind of interwoven, which is that if we move to a more rational system, a lot of the costs, and you eliminate the need for kind of a step one, step two, that some of this administrative burden would be removed.
Other questions for Pepper? Thank you. So Peggy, if we could reschedule Pepper at another time, if he wants to come in and get a discussion with Judge Grierson, state's attorneys, VCIC, and the defense bar about whether we should go to sealing or how we should do this.
We're taking it up again next Friday at 8:30.
Okay, well, that'd be a good time to start looking at that if we get through Marshall's testimony. I'm going to jump ahead with Erica, if that's okay, and then go to Marshall. Erica, if you're ready, I saw you're there. I say you're here, but you're really there.
Yes, sir.
Well, please go ahead. Nice to see you again.
Thank you, sir. Thank you for having me back. I appreciate it. I just wanted to offer, I second that it seems like some of the efforts, while I appreciate, make things a lot more complicated. So I just wanted to offer for a suggestion that when you're looking at timeframes for making expungement available, if you're looking at years from conviction, well, somebody could be waiting for trial for years after they've been arrested. As in my case, it was only 1 year. I got arrested in 2005 and not convicted until 2006 because my case kept getting postponed, even though I was like, I'm guilty. Yeah, let's just get it over with. My case just kept getting postponed. And there were people I was in prison with who had waited 2, 3, and more years for their trial. So if you go based on conviction date, that extends things really far out. And so my recommendation, and obviously take it for what it's worth, is 10 years from arrest or 5 years from release or discharge, whichever comes later. And I'm saying that, again, as an offender. It's been very interesting to listen to the testimony today because I'm coming, again, as an offender saying, please make sure to take into consideration the victims of our crimes ahead of the perpetrator of the crime. As much as I would like the opportunity to have an expungement and kind of set that chapter aside, my victim deserves justice more than I deserve mercy. And that's just my personal opinion as a person who's also been the victim of a crime and been re-victimized by the system where that did not go to trial. So 10 years from the date of arrest or crime, I think, is a sufficient time period for someone to demonstrate that they've either gotten their life together or not. And as mentioned in an earlier testimony, if you make it from point of discharge or something like that, and a person is wealthy and they can just pay their restitution and be done with it, well, you don't want to make it unfairly easy for those people either. So I think a 10-year time frame is reasonable, or 5 years from discharge. So, let's say I had been in a better financial circumstance and I had paid my restitution off in a few years rather than in 9 years. That still gives enough of a time frame for there to be consideration. So 10 years from date of conviction, 5 years from discharge, whichever is later, allowing for that time for someone to be able to demonstrate that they have in fact been rehabilitated and can be trusted with having their rights restored.
It's an interesting idea. We have a case here in Bennington County where a man was charged in 1986, I think it was 86, with an L&L with a child. That man has claimed he was a detective from New York who came here and was accused of molesting a child. He claimed his health was such that he couldn't possibly stand trial. So his case is ongoing, and actually they're having hearings on it. They're scheduled shortly, and keeps sending motions in that he physically can't handle the trial condition. So even though his case is back to 86, if we went there, there has not been a conviction, but he was arrested in 80, I believe it's 86. So I mean, I realize this is unusual, but that's the sort of thing that you would run into, which would make it extremely difficult to use the arrest date. Joe?
I would agree, and I also agree with Erica that if you use the date of completion of the sentence, that presents a whole nother problem based on whatever the sentence is. It is right. In my brain, the date of conviction should be the start of whatever time frame we choose to use, because somebody may be dragged out for a very long time based on various reasons before they complete their sentence. But the other component to that is whatever time period you use, if you started with conviction, as long as there's an understanding that the petition itself for expungement or sealing also requires that the sentence be done. That the conditions in the sentence be done. That to me makes a lot of sense, but I would use any time that there's a time period attached to this statute. It should be the date of conviction from which we're talking about.
That would be another option. Now, again, that being said, trial can take a significant amount of time between the date of arrest and the date of conviction. And that may have nothing to do with the person who is on trial. Because as I said, I was told by a court appointed attorney to plea not guilty, basically to allow for there to be some kind of a plea bargain or whatever, with the intention that I was going to plead guilty, just they were going to negotiate what exactly I was going to plead guilty to. And the fact that that took an additional year actually was more of a hardship, because then I was just in limbo for a year, knowing that at some point in the future, I was going to be going to jail. So I couldn't get a job that would make any kind of a sense. It made it very difficult to deal with housing and all that other stuff. And so if it's from date of arrest, then that starts an actual clock for people. That is a meaningful time frame for their life to have changed, rather than when the court decides when they're going to convict them. Now, I'm saying all of this under the assumption that people still are going to have to apply, that this is not an automatic process, that people will still have to demonstrate a legitimate change in their life and the way that they're behaving.
Okay. Other comments, Erica, at this point?
The only thing I would say is, well, one thing, I second Mr. Pepper's comments, and forgive me for not knowing the appropriate title to give you, Mr. Pepper, but making it unburden, like, I'm grateful for the opportunity to get an expungement, but if you make it incredibly burdensome, I am a person who was capable of, as an example, putting together an expungement request and a governor's pardon. For me, it took months and months and months, and the help of an attorney at legal aid, luckily, but it's an incredibly time-consuming and emotional process. Not a complaint, just letting you know that that is what it is. And so if people have to go through that multiple times and then have multiple times have to get those letters of recommendation and things like that, it does make it much more difficult. And it should be, if you're going to offer the ability to have an expungement or a sealing or a pardon, it should be understandable and easy so that normal people without a college education can go through it. It's great that legal aid is there, but the capacity for that, the cost to, as Mr. Pepper mentioned, is just exorbitant. And I think one thing that your committee has to be incredibly careful of, and I do not envy you for this, is making sure that perpetrators are not given more care and consideration than their victims. Because again, as much as I've put my life back together and would like the opportunity to set this chapter behind me, my victim deserves more consideration than I do. I did something wrong and I deserved to be punished, and my victim deserves justice. And I think that that needs to be, in my opinion, the forefront of any decisions that are made by the Judiciary Committee.
Thank you. Yeah, appreciate your testimony, Erica, and thanks for being with us.
Yes, sir.
Have a great day. Marshall?
Thank you, Senator. So I want to start off by saying our office certainly supports the bill. We support the bill. We also support the changes that have been proposed by Vermont Legal Aid in its memo. But I want to get into a little bit more of the process and the next steps. And that'll get to the sort of one tweak that I see as being important in this bill as written that wasn't necessarily addressed by legal aid. So what I want to say is that S7 takes another step towards really expanding our expungement system so that it really works for the vast majority of people who are convicted of crimes in Vermont. But it still is pretty limited because, as everybody has testified, this is still limited to those offenses that are not listed offenses, that are not drug trafficking offenses. And some of those listed offenses are actually some of the most commonly charged crimes in the state of Vermont. And what I thought was particularly interesting is when you look at where Vermont's expungement laws fit with our neighbors, it shows that we still really have a long way to go. So if you look, for example, at Massachusetts, Massachusetts has a system very much like Vermont, where there's a two-stage process. There is sealing, and then there is expungement. Some offenses are eligible directly for expungement. Some have to go through a process of sealing before they go to expungement. But with the exception of serious sex offenses, none of those waiting periods are more than 15 years. And the list of offenses that Massachusetts completely exempts from expungement and says can't be expunged at all is actually very different from ours. So they actually have, 28, 29, essentially 29 offenses that are completely unexpungible, but none of them are based on the same criteria we're using. We're using the list of listed offenses, which are typically those offenses that are, serious interpersonal harm type of offenses. Whereas in Massachusetts, the completely exempted offenses fall into two categories. One is firearms sales licensing offenses. So not just any firearms offense, but things like selling firearms without a weapon, or without a license. I'm sorry. Obviously, if you're selling firearms, you have a weapon. Selling firearms without a license, transporting firearms into the state for sale without a license, things like that. There's four firearms licensing offenses that are exempted from their expungement laws. And then the rest of them are what they call public justice offenses. So it's tampering with witnesses, bribing public officials, jury tampering, perjury, things like that. Things where people have essentially broken a public oath or tried to manipulate a legal process. And then the only other offenses that are excluded are lifetime sex offender registry offenses. And that's because unlike I think in Vermont, pretty much all of our sex offenses at this point that require lifetime registration also have a mandatory lifetime max, and so would never be eligible for expungement anyway. But in New Hampshire, in Massachusetts, there's a lot of sex offenses that do require lifetime registration, but don't have a life maximum. But those are nonetheless exempted from their sealing and expungement laws. You go and look at New Hampshire, which has a much similarly has a much smaller list of exempted offenses. There, they have a single process. They don't call it sealing or expungement. They call it annulment, just like you can get a divorce or get a marriage annulled, and that makes it sort of as a legal fiction, as if that marriage never took place. That's what happens in New Hampshire with their expungement law, is it annuls the conviction as if the conviction never took place. And the only offenses that they exempt from their annulment laws are homicide, felony assault, kidnapping, felony arson, robbery, incest, sex assault on a child, felony obstruction of justice, and then any offense. They use a lot of sentencing enhancements in New Hampshire. So any offense where there's been an enhancement for either hate crime, crime committed by a on-duty law enforcement, or crime as a major source of livelihood. Those would be the only offenses that are exempted from annulment in New Hampshire. And the reason why I sort of go through that is just to give an illustration of how much farther we have to go in Vermont. And I would agree with a lot of what Attorney Pepper had to say about the ways in which our system of sealing and expungement is difficult and onerous, not only on people at VCIC who have to delete records, but on the people who are actually trying to get their records sealed or expunged. It is a very difficult, not very clear process. The number of people I've talked to who have said they looked into this and could not even begin to understand the process of expungement until they went to an expungement clinic done by usually legal aid. It's a very difficult process, and so I support doing anything we can to simplify that. However, where I disagree with Attorney Pepper is that the idea that sealing is somehow the answer to that. And the reason why our office has concerns about sealing has a lot to do with this exemption for legitimate law enforcement purpose. There's no definition of that anywhere. There's nowhere you can look in statute that tells you what a legitimate law enforcement purpose is and what it's not. And what we find is that law enforcement uses these records for exactly the thing that we're trying to keep people from using these records for, which is to look at someone and look at the offenses that they committed a long time in the past and make presumptions and change their interaction with that person based on those presumptions, based on that very old record. And so we see people who, if people get stopped on the side of the road, how does the cop approach that person? Do they approach that person as if it's a simple traffic stop? Or do they approach that person, suspicious of and looking for opportunities to request permission to search, to escalate the nature of the stop from a simple traffic stop into a criminal investigation? Do they do that on the basis of their knowledge of that person's record from 3 years ago, 5 years ago, 10 years ago, 15 years ago? And that's what we don't have any objection to moving from a system of expungement to a system of sealing, as long as what we're doing is ensuring that when we say that a record is unavailable, that it's actually unavailable, that it's not being used, that we're not digging back through these records, looking for information about people, looking for information about things that have happened long in the past, that we are actually doing what this whole process is intended to do, which is allowing somebody to separate themselves from that record and move forward with their life and not have every interaction with law enforcement affected by that past record. And that's not a minor thing. That report that came out just a few days ago regarding race and traffic stops had a lot of really fascinating data about the extent to which we still, despite all of the changes we've made, that we still have significant racial disparities in our traffic stops. But one of the statistics in there that really blew my mind didn't have to do with race at all. It just had to do with the fact that we have about, that we are far above the national average in terms of traffic stops per capita in Vermont in any event, race, without even looking at race. Just the number of traffic stops that happen in the state put us at something, I think it was close to 3 times the national average for traffic stops per capita. That got me to looking at just sort of the extent to which we as a state are policed. And we are, as it turns out, one of the most policed states in the country. When you look at number of active sworn law enforcement officers per capita, we're 3rd in the country. There's only 2 states with more sworn law enforcement officers per capita than the state of Vermont. And when you compare us to our neighbors, Maine has about half the number of sworn law enforcement officers per capita as Vermont. New Hampshire had about 2.2, that was Massachusetts, had about 2.2 sworn law officers per 1,000 residents, where Vermont had 3.4. I've forgotten what New Hampshire's number was off the top of my head. But so, this isn't an abstract concern. The idea that this information, if it's available to law enforcement to use in a fairly unrestricted manner, is going to be used really in exactly the ways that we don't want it used. It's really not abstract. We are talking about the use of this information in one of the most heavily policed states in the country. And so that's really our concern. And that gets me to my last point on this, and sort of the one area where I would suggest a tweak in the bill that's not contained within legal aid's memo. And that's around what the next step is, because I think that this process of changing our expungement laws and expanding our expungement laws has been fairly successful, but it's been incremental. It's been small steps, and that's okay. That's how this process has worked, and we've made a lot of progress that way. It would not, I think, necessarily make sense to sort of give up on the process that's happened so far. However, what I would say is, in the last section of the bill, hold on, I'm trying to pull the bill up and I accidentally just closed the window I should have had open, but there it is again. So the last section of the bill, section 6, directs the Sentencing Commission to consider whether a comprehensive policy that provides an avenue for expungement or sealing of all offenses will serve the interest of justice. My suggestion would be that instead of asking the Sentencing Commission the simple question, would this serve the interest of justice? It would be to direct the Sentencing Commission to develop and present to this committee or to Joint Justice Oversight a policy or proposed legislation that would, in fact, allow for the sealing of all offenses, including listed or drug trafficking offenses, or at the very least ask the Sentencing Commission to, make an attempt at that and to identify those offenses that are, categorically inappropriate for expungement at any time. And the reason I suggest that is the Sentencing Commission is a very large group at this point. I think every time I go to a Sentencing Commission meeting, there's more and more members of it. And these large commissions and committees are very good at being able to take a direction and do the work of coming up with policy or coming up with proposed legislation. The larger a group gets, the harder it is for it to come up with any sort of policy recommendation. And so my suspicion is that I could tell you exactly what the Sentencing Commission would say about whether or not it is in the interest of justice to provide an avenue for sealing or expungement of all offenses, which is they would say there's a split of opinion and part of the Sentencing Commission feels one way, and part of the Sentencing Commission feels another, because that commission has gotten large enough that on any sort of big policy question, that's what the Sentencing Commission says, is there's a split of opinion and some people are on one side and some people are on the other side. Whereas the Sentencing Commission does function really well when it's given a task. We have great subcommittees. There's a lot of expertise on the Sentencing Commission. And so when it's just given as a like, let's come up with some language, let's come up with some policy, let's come up with some legislation, Sentencing Commission is great at that. That can then be reported to this committee or to Joint Justice Oversight, which can take testimony from all the stakeholders and make the policy decision about, is this in the interest of justice or is this not?
Oh, that's a proposed change that we can take up. I've got to end right here because there's another meeting at 12 noon for Senator Baruth and I with chairs of the House Judiciary and Corrections and Institutions Committee. And Peggy has to end this meeting before she can start a second meeting. And she might need 5 minutes. I might need 5 minutes.
Well, not only that, I think it will end abruptly without me even doing anything.
All right.
We have a different Zoom invite
Yes.
for that meeting.
Yeah, it's a different Zoom.
We have to
Yep.
go out and come back.